Yeah. Yeah, is this enough? Is this enough? This isn't enough here. Of course, once again, sorry, whatever's not even well, none of them. Okay. We don't walk in the yeah, Claire, yeah. It depends on how they fit in the memory, right? Like if we put Claire, if we figure that it's kind of John, Claire, right? Then I can say she. I think that's John, right? Yeah. That's John. So here, Claire here, me here. Now we have someone, a colleague of them the year before, and then he did that, and then Andrea Clemens reached out and said, it just happened in 2 weeks, and so I'd love to talk to you about it. It's my first time talking about it. And then that's where
for example,
You have my contact
Yeah, exactly.
I'm not sure what that means. I don't know.
I get a sign on some
Good afternoon. I'm Will Brownsberger. I'm the Senate co-chair of the Joint Judiciary Committee. To my immediate left is the House co-chair of the Joint Committee, John Fernandez. Far off on the left is Jean Mooney on my staff. Jim McCarthy, Representative Fernandez's staff. Paul Donato, Representative Rose, Gretchen Bennett, Keith McFarland. And going off to my, who are all members of the House Committee staff except for,
It's okay.
did I pass it over?
Yeah, you did.
Vice Chair Claire Cronin, thank you for leaning back. It's all it took for me to blow it. I apologize. And coming in this way, we've got Representative Day, Senator Ross, Representative Beavers, Representative Tucker, Representative Harris, and Harrington, and to my immediate right, my chief legal counsel. So, without further ado, we will get going. We will be limiting testimony, as we always do, to 3 minutes. We're going to start with the representatives who are lined up, and then we'll go through the list. I've got, in the order that I think they were first identified themselves, is Senator O'Connor Eisner? All right. Brooke Manel? No?
Thank you, Senator. bringing with me Michelle Conover. She is the constituent for whom I filed the legislation, so I'll get straight.
You want to do that one, that's our magnifying.
Oh, this one's the magnifier? There we go.
That'll just get you on TV.
No, yeah. And we're going to turn that one away. Thank you for having me, members of the Judiciary, Chairman, and Vice Chairman. I'm here today to testify in support of House 3445, which was a bill I filed by request on behalf of Michelle Conover. Just as a bit of background, I'm going to leave the committee with 2 articles, one from Boston Magazine and one from Wicked Local, which gives some background information around the reason why this bill was filed. And to quickly tell you the story before handing it over to Michelle, because she has very much been a champion of this in Yarmouth. We, as many of you know, hail from Cape Cod. Cape Cod is very much a residential community, but it's also a resort community. And so during the summer in particular, we have families from around the nation and certainly from around the Commonwealth who come to our community. Last year, in 2014, there was an incident in which a level 3 sex offender who was registered as being homeless was living in a bus and was going around to parks and beaches, the places where children normally congregate, and sort of setting up shop and moving along. The Yarmouth Police Department became concerned and actually issued an advisory to tell residents to be on the lookout and be vigilant, because this is someone who is known to reoffend and had offended against children. It was a shock to me to learn that that's not particularly, it's not illegal. There's no prohibition against that. There are similar laws that have been struck down recently, but they are very distinguishable from the legislation that we've proposed here, insofar as this legislation has no residency restrictions. But basically what we're seeking to do is to create child safety zones, which are places where children are known to congregate, and for the specific purpose of not allowing pedophiles, level 3 sex offenders who have committed acts of abuse towards children, to be able to loiter and engage with people who could potentially become victim of their press. So with that, I'm going to hand it over to Michelle to give her testimony on the bill. I will also just quickly say that our Yarmouth Chief of Police has submitted a letter in support of the legislation, and that legislation that essentially mirrors this was passed by the Yarmouth town meeting earlier this year. Michelle.
Thanks. Hi, Michelle Conover of West Yarmouth, Massachusetts. According to the National Conference of State Legislators, Alabama, Florida, Montana, Oklahoma, South Dakota, and West Virginia have state laws that prohibit the loitering of convicted sex offenders in places frequented by minors through the creation of safe zones for children. Massachusetts does not. You see, like most people, I assume that registered sex offenders in Massachusetts who have been convicted of committing crimes against children aren't allowed to go where children congregate. I was one of those people, I believe that. But this summer, when I learned that the white bus with the suspicious driver who had been parking at the beach at the end of my street belonged to a registered level 3 sex offender, like any parent, I was concerned. And when I learned that there were no local or state laws that restrict where registered sex offenders can go, I was filled with disbelief. So much so that I began doing research, and through my research, one thing became clear. A law that would prohibit registered sex offenders who have been convicted of sex crimes against children and who are classified as having a moderate or high risk of reoffending from congregating in areas that are child-centered allow police to effectively do their job, protect our children, and safely take action against those who are loitering in areas where they can cultivate relationships with those whom they prey on. And those who treat sex offenders agree. The Council on Sex Offender Treatment says, sex offender behaviors are extremely resistant to change, so sanctions to both control and punish deviant behaviors are necessary in protecting public safety. In order to manage their behavior, sex offenders must have external controls, including child safe zones, and develop internal controls. Without external restraints, many offenders will not follow through with treatment. In November of this year in Springfield, Missouri, an already registered sex offender pled guilty to child pornography charges. Last year in my town, a man was arrested and later convicted and sentenced for secretly taking photos of young girls at local beaches. Do you know if a beachgoer had reported this suspicious activity by an individual to police, and the police learned that this individual was a registered level 3 sex offender who had been convicted of committing crimes against children just while gathering information about that subject? On that basis alone, he could not ask them to legally leave the beach because the current law says he has the right to be where those he preys on goes. That doesn't make sense. Since 2011, over 20 towns have passed sex offender loitering or residency restriction bylaws in the state of Massachusetts. While our bill does not include residency restrictions, the residents of these towns, by demonstrations of their votes at town meetings across the state, clearly support legislation that restrict those who have been convicted of committing sex crimes against children and have been classified as at a moderate or high risk of doing so again from having access to our vulnerable population, the population they prey on, our children. In 2008, a convicted child rapist and registered level 3 sex offender raped a 7-year-old boy in New Bedford Free Public Library. Let's not wait until another registered sex offender reoffends before putting parameters in place that keep convicted child sex offenders away from the children they prey on. Thank you.
Thank you very much for your testimony. Are there members of the panel who would like to ask any questions? Thank you very much for bringing this before us.
Thank you, and we will leave this with staff, the written testimony as well as the articles.
Thank you very much.
Thank you very much.
I see Representative Arciero, you have a panel of sheriffs with you.
I do, Mr. Chairman, thank you. I'm here with Sheriff Contusion and Sheriff McDonald from Plymouth County, Sheriff Contusion from Middlesex County. Thank you for taking us out of order, Mr. Chairman.
We will be brief. Busy day ahead of you.
Chairman Fernandez, Chairman Brownsberger, members of the committee. Oh, I'm sorry. I'm here today to testify on behalf of House Bill 1148, an act regarding asset forfeiture, a bill I filed with my former colleague, Middlesex County Sheriff Peter Contusion, and 18 other members of the House and the Senate. This important legislation would add crimes associated with child pornography and child enticement cases to our existing forfeiture laws, which have been instituted for crimes associated with controlled substances and human trafficking. This bill would enable state and county prosecutors to petition our courts for these assets if they were used in the commission of these serious crimes, and the individuals were subsequently convicted. Specifically, any item or asset used for the production, storage, or dissemination of child pornography or to entice minors would be cleansed and sold. The resultant funds would be used for internet safety education, victim rehabilitation and therapy, matching funds for federal grants to fund further investigation of these types of crimes, and the purchase of technical equipment for our law enforcement agencies. As you know, this bill last legislative session went out in a favorable fashion and reported from the Judiciary Committee. I hope you find its merit such action again this year, and I look forward to your decision through the committee. Sheriff Contusion and Sheriff McDonald are going to have a brief testimony as well, Mr. Chairman. Thank you.
Thank you, Representative, and thank you, Mr. Chairman, and Mr. Chairman and members of the committee. My name is Peter Contusion. I'm joined with my colleague, Sheriff McDonald from Plymouth County and the Sheriff in Middlesex County. I especially thank Representative Arciero for being sponsor of this piece of legislation. As soon as I brought this issue up to him last fall, he immediately became part of this and immediately jumped on board, as did the other sheriffs. For several years, the Middlesex Sheriff's Office was, we had a deputy sheriff assigned to the Northeast Municipal Law Enforcement Council Computer Crime Unit, and that's what spurred me on to create this legislation. Last year, our office established our own digital forensics unit to provide assistance to local police departments. And quite honestly, part of the reason was because it wasn't being resourced appropriately in its other place. These crimes, and greasers are always a challenge. These crimes are horrible, they're heinous, and the most heinous ones we catch on the headlines, but there are thousands upon thousands of other cases just like those that are not in the headlines every day, that are tearing apart families and communities across this state and across this country. And this, by the way, this work is noble work and it's really difficult work. When you think about these investigators going through file after file, video after video, in order to prepare a case, it's very difficult on them as well. This is public safety legislation. It's about the tools to provide the youth with the educational tools to protect themselves in the digital world. Is to give law enforcement the technical tools and expertise necessary to fully investigate cases, and to give the prosecutors the tools to properly try the cases. The proposal is based on the state's asset forfeiture statutes for controlled substances and human trafficking. And coast-to-coast asset forfeitures laws like this have been passed in such states as Alaska and Wyoming. This legislation is narrow and very specifically tailored to cover child pornography and enticement. It does not cover other forms of digital crimes. Massachusetts authorities can already obtain warrants and seize cameras, computers, cell phones, vehicles used by perpetrators in child pornography and enticement cases. This legislation would then allow the prosecutors, at the conclusion of the case, at the conviction of the case, with the court's permission, to dispose of the seized property and generate funds that can be put into 3 narrowly tailored areas. Number 1, digital literacy programs for youngsters so they can be empowered to learn how to protect themselves. Number 2, rehabilitation and therapy programs for the victims of these crimes and their families. And number 3, law enforcement efforts to identify, catch, and prosecute child sexual predators. Only for these 3 areas. Nationally, the National Center for Missing and Exploited Children estimate that 1 in 7 children who are regular internet users will receive sexual solicitations online. Indeed, 1 in 3 is exposed to unwanted sexual material. This is a concern of mine as my children are becoming more and more online as well. These cases are very taxing on manpower, and we need to enhance our ability to protect our children, to resource those that are doing these investigations, and I believe this is a really small step. And quite honestly, I don't know that there's going to be a great deal of money that is made throughout these seizures, but I do know that it will go to very good things that are very necessary.
Thank you, Sheriff. Members of the committee, my name is Joe McDonald. I'm the Sheriff of Plymouth County. I have submitted a letter in my capacity as the President of the Mass Sheriff's Association that you'll have an opportunity to read, so I won't belabor that point, but I wanted to just mention some anecdotal, some real-world information that we have done in Plymouth County. As Sheriff Katusian mentions, we are involved in a lot of these task forces, these multi-jurisdictional task forces, working together, federal, state, and local authorities to investigate and ultimately prosecute these crimes. In Plymouth County, we have something known as the HEAT Unit, the High Tech Evidence Analysis Team, which is part of our BCI, our Bureau of Criminal Investigation. So we have a special unit that investigates exactly these types of crimes. I wanted to mention also, approximately 8 years ago, when I first came in, we did a very large operation. It was known as Operation Trenchcoat down in Plymouth County. But as you can imagine, with the internet, these defendants came to us from many, many jurisdictions, some traveling great distances. We worked with the United States Marshal's Office, we worked with Immigration and Customs Enforcement, the FBI, the Massachusetts State Police, and many local police departments in Plymouth County. There were a number of arrests and a number of convictions that we got there. And it's interesting or alarming to note, I would suggest, that one of those individuals that was captured, arrested, and prosecuted and convicted actually traveled to the town of Marshfield, which is a municipal airport, in an aircraft, and had all of his accoutrements feeling or thinking that he was going to be engaging in relations with a 12-year-old child. This is exactly the type of person that we would like to go after, those assets. I also, Sheriff Katusian notes that those assets are specifically delineated certain funds. I would also like to note for the committee that the procedural safeguards that are in place would be the same as they would be with property seizures with reference to narcotics cases. People who allege to be innocent co-owners of those properties would have the opportunity to present in court with counsel, and judicial determinations would be made as to whether or not that property is improper for seizure. So there would be procedural safeguards to protect the property owners. I want to conclude by saying, I'm here as the Sheriff of Plymouth County and the President of the Sheriff's Association, but I'm here in a legislative role with reference to issues like this. I'm here as a dad. I have a 13 and a 7-year-old daughter, and they're the world to me, and I think this goes a long way to protecting people in that situation. So I'd ask that you look favorably upon this bill. Thank you.
Thank you very much.
Oh. Thank you, Mr. Chairman, and to the committee. I'm also submitting a letter that will break down the funding mechanism associated with the forfeiture as well. That will be part of my written testimony I'll be submitting as well.
Thank you very much. The question came on the one real quick question. What is the standard of proof to achieve a forfeiture? Is it the same as in 94C, or is it, what's the level of proof must be made?
It's the same basic language as the drug forfeiture and human trafficking law. So it's the same language. We've just, so if it's, I don't recall if it's probable cause or clear and convincing level in those cases. But I will say that we have refined and defined the only ways it could be spent in a much more deliberate fashion to make sure it was going to that. And I'll just say, when the reason that we established our own unit was when others were establishing their own units and the monies would come about, they had, they need to buy larger and larger computer equipment to handle the large hard drives, the large amounts of information, and my office had to pay $40,000 or $50,000 to get the computers set up to be able to do that for another unit. And in fact, when they receive some money, and Chief, you'll probably recall, often it goes to a vehicle, it goes to something tangible. It doesn't go into these, and so many more of our crimes nowadays, aside from child pornography, are committed digitally. And I just think it's really time that law enforcement step up and realize this is a digital problem. We need a digital solution. We need resources in a way that we never did before.
So clarify again the asset base that you'll be going after, and you mentioned money. How much do you think would come in based on the last year's experience, the last years?
We wouldn't be able to do an estimate on that, Mr. Chairman. What I can say is this: I really don't believe this is going to be making a lot of money. Whether or not an airplane is something that you would go after, I don't know. I'm just saying that it would be nice to have it's important to have a funding stream based upon the crimes themselves that then support the protection of the victims and the education for the victims and their families, and to allow the law enforcement the tools to investigate and the prosecutor the tools to prosecute as well. So it's not to make money, and any of the monies that are actually to be reaped from these sales, as they are with others, in a less narrowly defined fashion, would only go to those services.
Yeah, I'm not implying it.
Yeah, I understand, but that's
money makes a difference.
Right.
I'm just curious of the asset base. We talked about the equipment used, but would this extend for the public's understanding beyond the equipment, the possibility of a car being used, or a van being used, a plane
Yes.
being used?
Yeah.
In the stream example
Yes, it would.
Those would become assets.
Those would become assets if they were utilized in the commission of the crime itself. Yes, sir.
Correct. Yeah, if I may, Representative, it would be very similar to what we're seeing, the asset forfeiture with reference to narcotics.
Sure.
Generally speaking, it would be computer equipment that would be used to commit these crimes, as well as cell phones. That would be the vast majority of what would be seized, and the value of that is going to vary tremendously. I brought up the issue of the airplane simply because that brings home the extreme, as you correctly point out, possibility that exists here. There would also probably be motor vehicles involved.
Yeah. Okay. Thank you.
From my experience in the narcotics world, I would take it that if somebody was viewing images or distributing them out of their house, the house would also be forfeitable.
Mr. Chairman, yes, certainly that could potentially be. That's the case with drugs, the drug seizures right now. But again, I will say that this is not to make money, and as opposed to some of the other laws, it's so much more narrowly defined, only to be utilized for these services. So I don't foresee any. I don't foresee the problems that I think maybe you may worry about at all.
Thank you very much. Seeing no further questions, thank you very much for bringing this.
Thank you, Mr. Chairman, members of the committee.
Thank you, guys.
Representative O'Connell had signed up earlier. Representative Ryan.
Thank you very much, Mr. Chairman and members of the committee. I have 4 bills up, but I'm only going to testify on one. I'll submit testimony for the other 3. The bill I'm here to testify on is H3256. And what this does is it allows parents and caregivers access to level 1 information about sex offenders upon request at the police department. So it's not disseminating it online, but it's allowing parents or whomever from the community to go to the police department to get this information about someone that lives in their community. And I just want to start by dispelling the myth about public urination, because this is something that people always ask about when we talk about access to level 1 sex offenders. You do not have to register as a sex offender if you've been caught urinating in public. What that is you have to be convicted of two counts of open and gross lewd and lascivious behavior to have to register as a sex offender. And that's a pretty high bar to meet, because the person has to have exposed himself intentionally, has to do so openly and intended for people to see, and also intended for shock or alarm. So that's a pretty heavy burden to meet, a pretty difficult burden to meet, and you've got to do that twice. You've got to be convicted twice to register as a sex offender. So if you're a level 1 sex offender, it's because you have committed some kind of sex crime, and parents deserve to have access to that information to keep their kids safe. Because in Massachusetts, the way that we classify sex offenders, someone who has registered as a level 1 sex offender could have committed the same crime as a level 2 or even a level 3 sex offender, but be classified as level 1. And we all know that from the very tragic story of the Burbine case from Wakefield, where John Burbine was registered as a level 1 sex offender. A mother whose child he had access to had what she described as a funny feeling about him. She went to the police station, wanted to find out if he was a registered sex offender, and could not get that information because he was a level 1 sex offender. And we all know that he was later convicted of over 100 counts of sex crimes against children. In Wakefield, we also found out that 16 of the 17 level 1 sex offenders were convicted of crimes against child, and those crimes included rape of a child with force, rape and abuse of a child, and also dissemination of child pornography, and these people were level 1 sex offenders. And the Wakefield chief of police did not even know that. Nearly half of the state's approximately 2,400 level 1 sex offenders in Massachusetts were convicted of crimes against children. So I think all of our first priorities are to protect children in Massachusetts. Another tool in the toolbox for parents and caregivers is to allow them access to this information. It's all about keeping your children safe and having the right information to do that. And right now we're limiting access, and that is putting our children in danger. So I would respectfully ask for your favorable consideration on this legislation.
Thank you very much.
Honorable Chairs and members of the Judiciary Committee, my name is Jennifer Lane. I am the President of Community Voices, a child protection and victim advocacy organization. Thank you for the opportunity to testify on behalf of the following bills: 1150, filed by State Representative James Acero, and Bill 3256, filed by Representative Shauna L. O'Connell. If passed into law, it would make level 1 sex offender information available by request at a local police department. Currently, the public has no access to level 1 sex offender information. We need to empower the people to be aware. We are keeping this information secret. We have been telling our children for years that secrets are bad, but yet we keep level 1 sex offender information secret. Where is the public safety in this? There is none. We know of at least one parent who went to the Wakefield Police Department to obtain information on the John Burbine, the level 1 sex offender who was accused of victimizing infants as young as 8 days old. However, due to our lenient laws, the police department could not give her the information. Not only was she not given that information, the police department did not give her the information that she could have done a query check that would have revealed his previous convictions. It is also worth noting that query checks cost $50, something that makes unaffordable. The $50 charge for information only protects the perpetrator, not the public. If the law was intended to protect the public, then queries would be free of charge and there are greater access to level 1 sex offender information, and then we would be in a different place. The Sex Offender Registry the Sex Offender Registry conducts roughly 10,000 sex offender registry story background checks per year. Some of the organizations requesting this information include the YMCA, summer camps, Boys and Girls Clubs. However, by our law, they are not allowed to receive that information. They're only allowed to receive level 2 and 3. This gives a pass to all the future John Burbanks of Massachusetts. Keeping this information secret, Massachusetts sends the message that it would rather protect sex offenders instead of protecting our children. The sex offender website receives over 1,200 hits a day. Arguably, that's 1,200 people logging onto the website to obtain information to keep their children safe. Massachusetts has the most lenient laws for sex offenders in the entire country, not to mention we are not in compliance with the Adam Walsh Act. Child Protection Act and public availability to sex offender information is the main thing holding us back. In terms of dollars and cents, Massachusetts continues to lose hundreds and thousands of dollars in the burn grant funding due to non-compliance. We can wring our hands over the implied constitutionality issue with increased access to the sex offender information, but what seems to be missing is the acknowledgement from this legislation that we as parents have rights. The right to raise our children safely in our communities as our legislator is your responsibility to make sure we have adequate access to this information. Thank you.
Thank you very much for your testimony. Thank you for bringing this close to our attention. Other questions from members of the panel? Thank you very much.
Thank you.
Representative Brewer.
Mr. Chairman, through you, thank you to the committee. I'm here to testify on one of the 5 bills I have before your committee today. The other 4 other folks that are going to testify. This is 1364, House 1364, an act relative to reporting sex offender treatment outcomes by the Department of Correction and the Department of Youth Services. So if I were to ask any of my colleagues, state senators or state reps, if we know whether or not our sex offender treatment programs are reducing recidivism or not, they couldn't say yes, because we have no idea if our treatment programs are reducing recidivism or not. I know that for a fact. I was director of research for the Mass Prison System, and when I was there, I was actually blocked from measuring our programs, and I found that to be very frustrating. So we really need to know whether or not our programs work. We are spending money on it. We fund it in every budget. We are paroling people based in part on their participation in treatment programs, both at the DOC and DYS, and we have no idea if we're getting a better public safety outcome or a return on our investment for our treatment programs. What my bill is basically asking is that the DOC and the Department of Youth Services just produce a report. That's all I'm asking for. I just want to know if our programs actually work or not. Does the sex offender treatment program reduce sex offending after release from DYS or DOC? We don't know. We should know. A lot of folks sometimes say, well, Paul, it might embarrass the state if we find out our programs don't work. I don't think so. I think the hallmark of good government is to be self-reflective and to be critical of its own practices and to measure them in a way that will stand up to scrutiny with sufficient scientific rigor, so that way we know if something works. And if a program doesn't work, that doesn't cause me alarm. What causes me alarm is if we don't do anything with the information that we know if this program doesn't work or not. So that's where it's concerning. So this bill 1364 is basically just asking for the Department of Corrections and Department of Services to just measure the outcomes. I will personally do it for them. This is something that can and should be done at no additional cost to the state. I've got the skill set to do it. If they don't have people on staff, I'll do it for them. There's no reason why we shouldn't require a report. We're paying for it, our taxpayers are paying for it, we're depending upon this for public safety. So with that, I'd be glad to take any questions, and if time permitting, I would like to plug the one other bill I have.
Thank you. I do have a question, and I don't have the full bill in front of me, just a summary of the bill, but it says here that you want to provide an annual report regarding the outcomes of treatments upon the discharge from the departments. And that seems a little bit vague to me, because
outcomes of treatments. There are various kinds of treatments and such. So I guess, you say there's no cost that would have to be associated with this, but you're talking about a pretty wide spectrum.
No, the bill actually specifies it, like, that we're looking at the measure of reduction of recidivism, so that's reading as DOC and DYS both have definitions of that, so we're looking at one specific behavior that's coming back into the criminal justice system. In terms of the no additional cost, we have all the data there. I know that, I worked there, I was there, and I was blocked from actually doing it. As crazy as this might sound when I was knocking on doors campaigning for office, this is the issue I talked about. And it can be done at no additional cost because the data is there, you just need somebody to process the data.
So when you say measures of outcomes then of treatment, you mean only with respect to whether they become initiated into the DYS program or recidivism? I mean, I normally think of recidivism in a criminal kind of aspect. Are you talking about only if they are then convicted of a subsequent crime of a similar nature? Or are you talking about recidivism if they return for more treatment?
Well, DYS and DOC both use different definitions of recidivism. What I'm referring to here is the DOC definition of it. I'm quite honestly not entirely sure the definition of recidivism for DYS. But with DOC, it's reintroduction to the criminal justice system, and whenever somebody gets rearrested, that's flagging the law and board probation. So that's one way that we know everybody who's released from the DOC who participated in these programs, whether or not they're coming back into the system. So it's, like I said, the data is all there. It just has to be
Department of
processed.
Corrections would have to provide the data every time someone's, I wouldn't think arrest would make a conviction.
Yeah, well, the DOC currently does a recidivism report on what they look at is every single inmate that's discharged from the DOC. They don't do a sample, they look at the universe. And we know who's participating in these sex-offender treatment programs, and we know what their risk assessment score is. And the way to do this is then to go back into the general population and match a control group to the treatment group based on the risk assessment score. So you have two groups that have basically the same likelihood of reoffending, but the only difference between the two groups is that one group gets the treatment program, one group doesn't. And it's basically what's called match pair research design. It's not withholding treatment from anybody, but you're able to actually have a control group that has a sufficient scientific rigor that will allow you to determine whether or not the program works or not. And like I said, all the data is there, we just need to process it. And it's not being done right now. When I was at the DOC, I was told by my supervisor who was still there, you will embarrass us if you do this. And quite frankly, I don't think I would embarrass the DOC, I would have embarrassed her. She was there for 14 years and she didn't know how to do this. So, I think she was probably doing a little CIA on that.
I mean, I guess I'm still a little confused just on the fact that when there is any recidivism, any kind of court involvement, they records brought forward by probation that's going to show you whether they have been involved in a treatment program.
But just because somebody participates in a program and then reoffends, it doesn't mean the program doesn't work. What you need to do, you don't look at it on individual idiographic, you have to look at it on it's research methods 101. You're basically looking at two large groups of people, sufficient numbers. One group gets the treatment program, one group does not get the treatment program. You compare the outcomes over the course of time of those two groups. What we can't do is cherry pick one person who participated in a program and say this person was in the program and they reoffended, therefore it doesn't work. What the definition of successfully reduced recidivism is when it's statistically significant. And what that means is it's beyond the realm of chance, and it's within the way that, like, you used to do, trying not to say it in a scientific way, but you need to do a chi-squared test or a t-test to measure it, and that will tell you whether or not there's one group has a lower likelihood of reoffending than the other group, or not likelihood, one group did actually recidivate less than the other group. So you're not looking at one person, and you're not doing it each time somebody comes back in. You're looking at it over the course of time. And like I said, we can do it, we should do it. The data's all there. I'm getting really into the weeds. I know we've had a class on statistics in the judiciary in a while, but the point is that it's all possible. It can and should be done, and we can do it at no additional cost.
Thank you. Any other questions from members? Did you have one other thing you wanted to cover?
I'll keep it really short. My other bill, House 1365, is an act relative to sex offender classification. And within the Sex Offender Registry Board, one of the criteria used to determine whether or not somebody should be level 1, 2, or 3 is basically in legislation that says whether or not there's a mental abnormality. So what is a mental abnormality? Is it depression? That's got nothing to do with whether or not you're likely to reoffend with sex offending. Is it whether you had postpartum depression? That's got nothing to do with it. So what my bill is looking to do is amend the language, get away from the word mental abnormality, because that could be discriminatory towards people that have some type of, like mental disorder of some sort, anything, and get to the heart of what we're concerned about, and that's somebody with pedophilia. And pedophilia is a diagnosis as very clearly defined in the DSM, and so that's what we should be concerned about, not just any generic mental abnormality, which is, and those are the words in the law right now, mental abnormality, but it's too vague, and it could discriminate. It could also be used in a way that is not going to really help increase the chances of detection, or be more useful sex offender registries. So that, if I take any questions.
Thank you for bringing these forward. Thank you very much. Representative Woody.
Thank you. Thank you very much, Mr. Chairman and ladies and gentlemen of the panel. I appreciate you taking me out of turn. I am here to testify on House Bill 1549, an act relative to protection of persons with disabilities. And it's named Lisa's Law because it's named after a young woman in my district that came forward with her story. And if you would allow me, I would like to read you her own words. She is in the hospital now, has been there since mid-November, and she's actually under surgery as we speak. She is seeking protection of persons with disability equal to those protections that are already in place for those who are mentally disabled. And this is her story. Years ago, on Mother's Day, I was raped in my college dorm room. My rapist was caught and prosecuted to the fullest extent of the law at the time. Under Massachusetts law, my rapist was only sentenced to a maximum of 15 years because the law does not distinguish me from a fully functioning person. However, if I were mentally handicapped, there would have been no cap on the sentence my rapist would have served. I am not able to protect myself or feed myself or even take myself to the bathroom, but I am fully aware of everything that goes on around me. Due to that fact, I was not afforded the same protection under Massachusetts law as a mentally handicapped person. I am asking the Joint Committee on Judiciary today to help me change this gap in the law. I believe that physically handicapped people deserve equal protection under the law as mentally handicapped people. Just because we understand the crimes that are being perpetrated against us does not mean we are capable of stopping them. In my case, where my rapist came into my room and took away my lifeline button, I had no way of protecting myself from his actions that night and had the understanding of what was happening to me. To find out after that, I was not granted the same protection as a mentally handicapped person, felt like I was being violated all over again. The law was the only protection I felt I had, but it did not protect me equally as a handicapped person. I am terrified to know that my rapist will be released in a few years because I will never be able to protect myself. As I grow older and weaker, and the more spastic my body gets, I imagine this is also true of most physically handicapped people. This is why the law is so important to us. I understand that this law will not be retroactive, but to ensure physically handicapped people are equally protected in the future is reassuring. My hope is that you will agree that this law is necessary. Representative Poirier and I are not seeking a bill that is the first of its kind. We are seeking equal protection under the law protection that, if granted, will treat all handicapped people with dignity and respect. To sentence defendants as if their victims are full functioning people when they are not is wrong. We deserve the same protection under criminal laws that is already granted to mentally handicapped people. I thank you very much for listening, and we have been working on having this happen for a few years now, and I would truly love to see it become law for Lisa's sake and all those in her position before she is no longer with us. So I would ask your sincere consideration of this.
Thank you for bringing this important bill to us. Are there questions from members of the committee?
Thank you very much for listening.
Thank you. Representative Chan.
Thank you, Mr. Chairman and members of the committee, for taking me out of turn. I'm here to testify on House Bill 1235, an act regulating the sex offender registry for the 21st century. Norfolk County District Attorney Michael Morrissey unfortunately cannot come, but has submitted his written testimony to staff already. This bill very simply requires sex offenders to include as part of their registration their online identities, email, Facebook accounts, Twitter, and other forms of social media. Currently, the sex offender registry only requires home address and work address, and nothing more, and that was implemented in 1999. So obviously times have changed since then regarding how we communicate, and who you communicate and how you communicate with it, can you figure out who they are. This bill was first submitted in 2008 as an update. Since then, in 2009, New Hampshire enacted a similar bill. Michigan, Iowa, Illinois, Louisiana, Florida, and Colorado have all initiated similar type laws regarding online identity for sex offenders. The bill does not create new penalties. The bill does not create new people to include as sex offenders. It only requires the current application forms to add one additional piece of information. We believe the cost should be very low overall because all you're doing is just adding a little bit of information as opposed to, a large-scale request. And it also gives law enforcement the ability to monitor sex offenders in a public forum. If you're posting on a blog or Craigslist or Twitter, you're out in public so you can be seen. Conversely, it also rules out sex offenders that they weren't the incriminating party if we know who they are online. So it does the opposite as well. So just very briefly, my testimony of this, very simple bill to update the law.
Important concept. Are there questions from members of the committee? Thank you for bringing this to us.
Thank you for your time.
Senator Ross, did you wish to testify or is it? Thank you.
You knew I'd be in the right place.
There you are. The right time. Okay.
Thank you, Mr. Chairman. Chairman Brownsberger from the Senate and Chairman Fernandez from the House, as well as fellow colleagues. I'm here to testify on 3 bills today. I'm going to try to make it really brief. S-891 is an act relative to unsealing of records. People that feel that they've been victimized and obviously suffered the injustice of being a minor and having something terrible happen to them. This would unseal the records so that when they're adults, they could actually see the stuff that was filed at the time. It makes important changes in the way the Commonwealth treats sex-related crimes, thereby enhancing public safety for our communities. This would allow a victim who was a juvenile and the offender an adult to access sealed records relevant to the offense. Victims of these heinous crimes deserve the utmost care and respect, and these individuals have the right to access information regarding their case and related to the events. Next, I filed Senate Bills 894 and 895 to address issues with the other side of these terrible crimes and the way that convicted offenders are handled. Senate Bill 894 would require Sex Offender Registry Board to prioritize the registration process of sex offenders who are convicted of sexually violent offenses or sex offenses against children. It also requires a minimum level 1 lifetime registration for individuals convicted of these offenses as adults, and a 20-year level 1 registration for those who are convicted as juveniles. Senate Bill 895 would require every offender convicted of a sexually violent offense, an offense against a child, to be registered as a level 1 sex offender until they receive their final classification for the Sex Offender Registry Board, because too many people fall through the cracks waiting to be classified. These offenders have been convicted of atrocious crimes, and it is important that we provide our law enforcement with the tools they need to keep our constituents safe. That involves taking the necessary precautions to ensure that these dangerous offenders receive appropriate amount of monitoring and supervision, as well as allowing the community to be aware of their presence as a dangerous sex offender. It's my hope that these bills would accomplish those goals, strengthening our public safety system, ensuring that our communities are better protected from dangerous offenders. In conclusion, I ask my fellow committee members to keep these important concerns in mind as they consider this legislation, and I respectfully request that these bills be issued a favorable report. Thank you very much.
Senator Ross, thank you very much. Any questions from members of the panel? Thank you.
You're very welcome. Thank you.
Now we're going to go to Women's Bar Association, Kimberly Doherty, and Ian Hayes from the Women's School of Law.
Good afternoon, Chairman of the committee, as well as the committee members. Thank you for having us here today. My name is Kim Doherty. I'm the president of the Women's Bar Association. We are here testifying in support of Senate Bill 1116 and House Bill 1530, an act establishing civil and criminal penalties for female genital mutilation of minors. We urge you to give a favorable report on these bills to protect girls of this Commonwealth from gruesome acts of female genital mutilation. These acts result in excruciating pain and long-term health consequences, including hemorrhaging, scarring, abscesses, infections, sexual and reproductive consequences, and oftentimes even death, either during the procedure or at childbirth later on. These injuries are serious and they're real, but they're not only physical injuries that are being parted on these girls in our Commonwealth. It's not only the violent and painful act that is occurring to them. This is also a means to instill fear and exercise control over these girls. Now, all of the girls of our Commonwealth, not just some of them, should be protected from these heinous acts. The Senate bill and the House bill will give local law enforcement the authority and the ability, and courts a mechanism to punish those who are both committing these acts, consenting to these acts, aiding and abetting these acts, and allowing girls to be removed from the country to have these acts imparted upon them in what's so-called vacation acts. The Massachusetts legislature will also provide remedies through this bill for family members to object to these acts occurring to their children or their other family members. It also provides civil and criminal remedies to the victims who are undergoing this female genital mutilation. The Commonwealth cannot sit idly back and allow for this to happen to our girls. 140 million women suffer today from female genital mutilation. 30 million girls under the age of 15 are at risk. And in Massachusetts, we rank 10th in the country for girls who are at risk of female genital mutilation. The populations of Boston, Cambridge, and Newton are the 10th highest in this country. We cannot claim ignorance here. There are over 11,000 girls in Massachusetts at risk right now. We must join in the other 24 states that have passed laws to provide criminal and civil remedies to victims of female genital mutilation. Even the most conservative state of Texas has passed laws to protect their girls. I would think we can do better than Texas. So we ask on today, Giving Tuesday, that you do the right thing and you give protection to the girls in the Commonwealth, and that you vote favorably and report favorably on these bills. Thank you.
Good afternoon, and thank you to the members of the committee for having me. I've worked on this issue over the course of 2 decades as a protection officer for the United Nations and as a professor and an attorney. I've worked on hundreds of cases involving women who have a well-founded fear of being subjected to FGM if they're returned to their home country, or hold those fears for their daughters. I've also worked on many cases on behalf of women who have already undergone FGM, but who fear medical and psychological complications should they be forced to return to their home countries. And until recently, women seeking asylum in the United States who had not yet been subjected to FGM had an asylum claim, while those who had already been subjected to FGM did not have an asylum claim. Because many asylum practitioners believe that this reasoning was flawed, I agreed to write an amicus brief that I submitted to the Fourth Circuit Court of Appeals. My argument highlighted the flawed logic and inconsistencies between the federal branches of government on this issue. The result of our appeal was stunning. Attorney General Holder took the case under his direct advisal, reversed the lower court decisions, and changed the law, asserting that our arguments were legally sound and more consistent with the US government position that FGM was, as he said, rightly condemned both domestically and abroad. From the day of the Attorney General's decision forward, a bona fide asylum claim of either a fear of future persecution or a fear based on having already been subjected to FGM in the past are now both valid cases for making an asylum claim. I've been asked today to speak to this issue not from the perspective of a defender of human rights and refugees, which I am, but also as a professor of constitutional law, which I also am. I therefore approach the question as follows. When the Constitution of the United States is either silent or otherwise does not prohibit parallel state laws, when is it advisable for states to pass such state laws? There are three approaches to answering this question, and the first is to look at the law. The answer here is straightforward. There is no preemption. Nothing prevents the state from passing parallel law in this context. On the contrary, it's well understood that states have their greatest powers in the arenas that most directly impact their residents, predominantly the areas of health, safety, and welfare. The second approach to answering the question is through policy, and here there is very good reason to pass this law. State governments and state and local law enforcement are often closer to and more intimately connected with their residents. This connection allows for greater access to local communities, particularly those which are often insular, isolated, or less assimilated, such as the likely target population for this proposed law. The third and final approach to answering this question is examining resources. Where federal resources are stretched or federal priorities are focused elsewhere, cases that might otherwise be considered to violate federal law will go unpunished and victims unassisted. A good example here is the Trafficking Victim Protection Act. Thus, state law plays an important role in providing tools to state law enforcement to respond to harms committed within the state. For all of the foregoing reasons, it's my opinion that the bill should be adopted. Thank you very much.
Thank you very much for that closing testimony. Are there questions from members of the committee?
What protects the act today from being a criminal act or a civil act subject to suit?
It's my understanding that it would be a battery and that this would create a cause of action. Yes, it would create a cause of action under both civil and criminal law.
So battery is a dangerous weapon.
Potentially, depending on how the act would be carried out. I'm not a criminal law expert, I should say, in answering this question.
But a battery for assault battery.
I believe so, yes.
Of civil law. Are any of those actions being brought criminally and civil? Does anybody know?
I'm not aware.
I think there are some jurisdictional issues that this act will alleviate that would allow for the civil action to move forward when this crime occurs outside of the United States. That is one of the loopholes that this act would seek to overcome, to allow girls who happen to go on these vacations and get mutilated to come back and actually have a cause of action. And to have a cause of action against parents who consent to it, to have a cause of action to any family member or person who actually aids in removing them and taking them on these vacations. The current law does not allow, as far as we've seen, that type of broad approach to allow one jurisdiction over the action and to allow all of those categories of people who are participating in this act to be held responsible.
That does start to indicate preemption, even though you made the argument that constitutional will not bar from doing it. But focusing on an act committed here in Massachusetts against a young girl or a mature woman within the boundaries of our state, there's no doubt that would be considered, there's no protection under our law, and it could be considered both criminally and civilly actionable. Would
Yes.
you agree with that?
Yes, if it's happening within the state, that's accurate.
But you're not aware of any action being brought in criminally or civil?
We're aware that the majority of these incidents are happening outside of the state. There are facilities within the Commonwealth that would not be willing to do any of this, that have grave concern over inflicting that type of pain and harm upon women. So what we are seeing, the majority of what we're seeing in the studies are showing is that these are called vacation harm. That's happening when they're sent back to Somalia or Ethiopia.
Do you have some numbers on that?
We do have some numbers. I believe it's in my written testimony as well that we submitted, which is a little different from the oral testimony. In 2007, well, it was in 2000, so it's a little dated, the Brigham Women's Hospital found that 228,000 women and girls in the United States either underwent that type of genital mutilation or were at risk of it. In that Massachusetts, there were over 5,000 women that were at risk of it. With respect to whether it was occurring here or not, the study doesn't talk about that, at least the study that we've seen, but we could take a look to see if there's anything specific.
Yeah, because there's at risk and actually happening. So it could be a very, very parallel group, or it could be a very diverse group, or different group. And whether it's happening here, or it actually happens or someplace else, would be important information.
Yeah, that's something we could supplement.
I just wanted to make sure we were clear that this wasn't a practice that, and I'm asking to be clear, more than saying it's clear, that this isn't a practice that has some privilege or protection today in the North Law that's allowing it to proceed and not be actionable.
Yeah, and as I said, I think it's a jurisdictional issue in terms of the acts not occurring here. So, but we can look to see if we can supplement our testimony related to specifically what's happening here versus what's happening on these vacations.
That's great, thank you.
Representative Aaron.
Thank you. As you know, we heard a lot of testimony on this bill a couple of months ago, and I think the jurisdictional issue was the issue then. And I commend you both, and this is a horrendous thing that you're trying to eradicate here. My question is, in order for us to overcome that jurisdictional element, is it the conspiracy portion of the bill that says that if someone here in the Commonwealth conspires to take somebody out of the Commonwealth to do that, then they're charged with the Section 9, basically, crime of conspiring to do this? Because we weren't sure how jurisdictionally it would ever work that we could go after people that did it outside of the country.
So it's more broad with respect to the people who consent to it, aid it, and allow the removal of the child from the country for it to occur. When it happens in another country, the current state of the way that this law is written, we don't foresee that there would be an avenue to actually finding the person out in Somalia liable and bringing them to our courts and prosecuting them here. That's not what the bill stands for. The bill stands for making it criminally liable and providing civil remedies for the people who are a part of this process, the parents who consent to it, the family members that buy their airfare and bring them over for it. So it would be more of the people who are responsible for aiding and abetting. And so under the House Bill Section 4B, it specifically sets forth all of those areas. So the first area is when someone commits it here. Perhaps that'll happen, but it gives you the avenue to hold them liable. But what we will probably see is people being held liable more under Section 2 for removing a child from the Commonwealth, Section 3 from assisting, Section 4 for consenting, and Section 5 for aiding and abetting.
And has that, and I'm sorry to be talking about this here, but has this statute been implemented and tested anywhere in terms of that jurisdictional request?
So 24 other states have various, let me just look to my cheat sheet on this, have various avenues of recourse for people who undergo this.
But for country jurisdiction?
I'm not sure that they are actually holding people outside of the country liable. No, it's different from that. It's similar to our bill in many ways.
Someone who assists, aids, and conspires to take somebody out of the country,
right,
like the act here, is jurisdictionally okay.
Right. So it's called the vacation provision, and so of the 24 states, 1, 2, 3, 4, 5, 6, 7, 8, 9, at least 9 of them, and then parent and guardian being subject to prosecution is almost all of those 24, probably 20 of the 24.
So could somebody be held liable before the act's committed?
Well, it's contemplated actually in this act that the Department of Children and Family Services and the Department of Mental Health can provide services to children who are at risk. And there's a particular section of the act that deals with that, which would allow an actual petition by the DCF to be filed. That's section 39M. Where the DCF can actually file a care and protection petition, and then the potential child who's at risk will be appointed an advocate who can then be there and hopefully prevent this from ever happening.
Anything that would stop somebody from doing that, DCF from doing that today?
I don't know that there's anything that would stop them. I can't speak for them, but this would specifically, it's a shall, I guess, so it's not must, but it's a shall provide these services. And so oftentimes you need something to be in writing to ensure that DCF and the Department of Mental Health are providing these services. So I think this would be a reason for them to act, and it would give them the authority to provide those services. And I can't speak for DCF and the amount of resources that they have and whether or not that they would provide these services under circumstances where the law wouldn't require it.
Well, if we have 5,000 people with risk in Massachusetts today, and we consider it to be an important act and danger to a child or a woman, if it's a child, would there be anything that would prohibit DCF from acting on that today? Would it be within the jurisdiction to act today?
I don't think there's a prohibition for DCF from ever doing anything like that, but of course this would encourage them to act and to ensure that they're protecting the children.
Thank you.
You're welcome.
Thank you very much for your testimony. I see D.A. Ryan. Did you wish to testify, D.A. Ryan?
I do, thank you. Thank you, and thank you for hearing me out of order. I'm here to testify with respect first to the bill that you're just hearing about, which is Senate Bill 1116 and House Bill 1530. And I'm here to speak both for myself and on behalf of the District Attorneys Association. We have strongly supported this bill, encouraged you to support this bill, to pass this bill. As you've just heard, this is something that Massachusetts needs to have in order to allow all of its residents to be fully healthy. With respect, Mr. Chairman, to your question about DCF, DCF can intervene in these situations where they understand that there's something contemplated for a child. It is often difficult to know that ahead of time. This is obviously something that is held very deep within the family. It is very rare. I've been a prosecutor for over 30 years. I've only once had one of these examples come to light beforehand, and that was because there happened to be some information that was shared at the school. To their credit, DCF did step in to intervene. It caused a rift in that family that never really healed. It is something that we need to understand is occurring, that either children are being sent out of the country or there's some attempt at times, which is even worse in terms of the kind of mutilation, to do things themselves in a home or with providers that will come to the house. This is something that's been condemned by the World Health Organization, by 24 other states, and Massachusetts as a leader in safe practices in good medicine should join that group in condemning this practice. So we are urging you to vote favorably on this bill. Questions?
Would you, and please don't interpret to the point you just made, any of the questions I asked as being in any way condoning of the behavior.
Mm-hmm.
What I like to understand with legislation is the level of its importance in achieving the outcome, because what you just described is the difficulty the DCF had isn't going to change because we have the legislation. The difficulty within the family, the difficulty getting people to report, that's all going to continue to exist. So, in fact, what I'm trying to get at and understand is whether there's a gap that exists in the statutes today, either civilly or criminally, that prohibits us from acting on this right now. And whether, in fact, if we were aware the situation is happening, one, could you bring criminal charges? Two, could a person bring a civil suit for damages? And three, could DCF act today? And if all of those three are available to us, then I'm curious as to why we're not acting in that way. And if they're not available to us, I'd like to know what the privilege or waiver is or whatever statutory provision prohibits us from doing those kinds of things. So I want to make sure that we're really lifting the issue up when we talk about legislation, not just publicly, because sometimes, yes, legislation can be helpful to raise the discussion and make it clear to think about a particular matter. But if the matter's been going on, and it's been going on for a while, what's stopping us from doing it?
I think there's two things. I think one of which is what you highlight, which is the fact that this is very difficult to be disclosed. It's hard to investigate these issues. You're right that that will not change. I think that one would hope from this type of legislation is the kind of public education. For instance, I could envision that we would include this in the training our office provides for DCF, so that and we provide for schools. So that in the case that I mentioned where there was some reference to something in a school, someone was alert enough to realize what the child was talking about and to make that report, I think we could change that level of discussion in educating people as to what it is and to the fact that it happens here. What I think we lack criminally is if someone today were to decide to send their child to wherever out of the country in order to secure this type of procedure. I don't know that DCF could act on that. With the level of certainty we would need, I don't know that. And I don't know that just understanding I had purchased a ticket to send my child to their grandparents, wherever they might be, that there would be any indication or probable cause for neglect to allow DCF to act. So I think this would change that, coupled with if you had an understanding of where the child was going, the prevalence of this practice in that country, I think you would be able to look at that and you would have some potential to act to stop the child going. I don't think we have that.
Okay, well that's interesting, because that's one of the questions I had asked earlier. We have to wait for the act to be committed if they're sent out of the country before we can come back with certainty and bring the charge that they were sent for that purpose. Do you think this law will change?
I think you could. Well, do I think that will still be difficult to gather that evidence? Yes, I do. I think that, like many things, that will change over time and with education, and this is the first step in doing that.
Thank you.
Thank you.
Thank you very much, Steve. And hold on a second, does any other questions from members of the panel? Thank you so much for coming in.
Thank you. I am here to testify as well on two other bills, one of which I know Representative Long is going to testify with me.
Why don't you feel free to make us aware of those as well?
That's fine. Thank you. I am also here to testify in support of House Bill 1558, an act defining the inducing of a minor into prostitution. This is a bill that really is a fix for the legislation as a result of a hole that was discovered by Commonwealth versus Matos. In that case, the Supreme Judicial Court said that in order to be charged and convicted of this crime, it was a factor that the Commonwealth had to show that the child that was being induced into prostitution had never, him or herself, engaged in prostitution before. So if the child, what happened in that case was it was a child who had actually engaged in an act of prostitution on their own, then was brought to a larger career of prostitution by someone else who was charged and convicted. And it was found to be a defense that the child had on their own come to prostitution before the adult had been involved. I think that is not what the legislature contemplated in its desire to protect children. And certainly if you just think about the societal piece of this, if you think about the child who has found their way into prostitution on their own and then becomes virtually a possession of somebody else, they are exactly the people we want to be protecting. And the fact that they may have exchanged the sale of themselves for food, for drugs, or for something else on another occasion should not preclude them from being protected by the statute. So this would change the statute to include bringing them to prostitution. It did not have to be the first time. And it is that fix from that statutory piece. And the next bill is House Bill 1443. This is a bill which would extend the statute of limitations for the crime of incest. Presently, the statute of limitations which is 10 years, which is shorter than other sexual offenses, begins to run at the age of 16. So when the child turns 16, having endured sexual acts of incest within their family, that is when they must come forward to bring the charge. And they have 10 years, so it's essentially until they're 26. this proposal would change that to begin at the age of 18. I think that is a sensible change if you realize that at the age of 16, the child is often still living, still legally and financially dependent upon the person who may be their abuser. It makes sense to wait until they're 18, they're emancipated, they may have gone off to college, they may have moved out of the house. That is a time when they might be much more willing to come forward. As I mentioned as well, as you know, the statute of limitations for other sexual offenses is much, much longer. So it's already a short period of time. And if it starts when they're 16, by the time they may be 18 or 21, they've already lost a substantial portion of time. So I'd urge this passage of those bills as well, both of which I think extend the protection to children, which the legislature sought to do by the changes in the statute.
Thank you very much, Dean Ryan.
Thank you, and I appreciate you taking me out of turn.
We'll go now to Judge Vernier and the panel on the age of consent.
Oops, so sorry. I don't know if both phones are working.
Members of the committee, I'm Jenna Bernier. I'm Executive Director of Mass Kids. We're a 56-year-old statewide child advocacy organization. I'm here today to testify in favor of Senate Bill 868 and 869. These bills have been referred to as the age of consent, not a defense bills. These bills would provide that any person or contractor working in a public or private school, an institution of higher learning, a state department, or a private institution providing services to youth, and who engage in sexual abuse of a person under the age of 19 served by such institutions may not use the age of consent of 16 as a defense in a civil or criminal action brought against them for such sexual misconduct or abuse. In other words, the bill makes it clear that youth in these settings shall be deemed incapable of consent to sexual relations with such an employee or a contractor. Now you may say, why do we need these bills? Well, it's because of the strategy of some abusers to groom young teens and then, in order to avoid future criminal or civil actions, engage them in sexual intercourse once they reach the age of 16. Youth who are targeted victims of these sexual offenses are often led to believe by their abusers that they are in a unique love relationship, that the sexual contact is consensual, and that the adult will leave their spouse and live happily ever after. Often these young teens only later learn that what they thought was a romantic relationship was just one of a string of inappropriate serial sexual relationships involving other youth. Now, because Massachusetts age of consent laws do protect abusers from criminal and civil actions, law enforcement's hands are tied, and the families of these young victims are left with little recourse other than to demand the resignation of such persons from their positions in public or private agencies, schools, or youth organizations. By the way, the Massachusetts Chiefs of Police Association is fully endorsing these bills. I'll give you a quick case in point. The case of Amber Jennings, a 30-year-old English high school teacher who engaged in sexual relations with a 16-year-old student. When the law enforcement officials in Dudley sought to file formal charges against her, they discovered that statutory rape charges do not apply for anyone over age 16 and under 18, even though these individuals are still considered, in most cases, to be minors. They also found that nothing in the law addresses the abuse of position which takes place in a case involving an adult with significant authority over a youth. In this case, authority can be a powerful force against telling or breaking of an unwanted and inappropriate relationship, because this authority can determine grades, school performance ratings, college references, all of these things. In this particular case, Ms. Jennings also sent nude photos of herself to the student, and so prosecutors were able to charge her with disseminating harmful materials to a minor. She pled guilty to those charges and received a 2-year probation. She surrendered her teaching license but was not placed on the sex offender registry. There are other cases that we can talk about this morning, but these young women here in front of me will give you some very powerful information. The point is that because these cases are not being prosecuted, and because the Department of Elementary and Secondary Education information about teachers whose licenses have been revoked is not readily available to the public, Employers and unsuspecting parents have no way of being alerted to the sexual misconduct posed by these individuals in their community. As an NECN investigation uncovered, individuals like these are then free to seek employment in other settings where they have access to children and youth. Individuals, for example, have been found to become private tutors, music teachers, and even a yoga teacher for teens. Now, it's important to say that the vast majority of teachers and school individuals are ethical, committed individuals who don't exploit children in their care. But it would be inaccurate to characterize these cases as rare. The U.S. Department of Education, in a report, indicated that 10% of school children from K through 12 are reporting that they are experiencing inappropriate sexual contact in their school, and in a third of cases with a teacher or a coach. According to another recent review of Massachusetts state records by Channel 5 investigators, they found 142 educators whose licenses were suspended or revoked over a 5-year period, and more than half of those involved sexual misconduct. They estimated that, very conservatively, 15 educators per year are involved in these cases. But I must share with you that there's an estimated 90% or more of such cases that are never reported to authorities. So these figures tell only a very partial story. Just briefly, we urge the committee prompt passage of these bills so that those who use their positions of authority to groom and then sexually abuse youth in their care will get the strong message that Massachusetts law will no longer protect, excuse, and provide cover and defense for them and their sexual actions. Thank you very much. I'd like to introduce two members here. Laura Syracusa, who is a mother of a child who has unfortunately experienced this issue, and also our newfound friend Brenda Demers, who has had a similar experience. Laura, would you like to?
Sure. Thank you again for taking the time to hear my story. So this is my daughter, Kristen. She was 16 years old and one of the youngest in her junior class when she met her new Spanish teacher, Gustavo Perez, from North Weymouth. Mr. Perez was hired at Cardinal Spellman in 2007. Kristen was just finding her own, but still what I would consider vulnerable and very impressionable. Kristen was the perfect target for a person who was charismatic, worldly, cunning, and a predator 33 years older than she. He quickly built up a trust with our daughter, first by saying that she was the daughter he never had. In less than a year after meeting Kristen, he was able to convince her to have a physical relationship with him, to lie for him, and to ultimately leave her family for him. We instantly became the villains in Kristen's eyes once we learned the extent of their relationship. My husband and I hired an attorney and presented our case to the principal and president of Cardinal Spellman. To our knowledge, the school did not contact the police. They did do an investigation that included interviewing Mr. Perez, his family, Kristen, my husband, and I. After the investigation, the school determined that there was not enough evidence to fire Mr. Perez. Shortly thereafter, we came across a Sims card in Kristen's room that had very explicit photos of Mr. Perez. When presented with these photos, the administration at Cardinal Spellman fired him immediately and told us they were notifying the Archdiocese of Boston and the Department of Education. Since Cardinal Spellman is a private high school, Mr. Perez was not a licensed teacher. So although we were told he would never teach in the state of Massachusetts again, he was not on file to track. To date, we do not know where Mr. Perez is employed. He does, however, volunteer as the president of the Boosters Association for Weymouth's High School. In the past, he has also been a sailing instructor for youth at the Wassagusset Yacht Club in Weymouth. We contacted additional legal counsel, our local police department, and Weymouth's police department. Unfortunately, we were not able to take any legal action against him due to the current laws. He followed her to college, and ultimately, she left Providence College after one semester to move in with him and his family. This family physically has removed our daughter and mentally stolen her from us. Kristen has not been in touch with any family member, not her only brother, not her grandmother, aunts, uncles, or any close friends she has had in high school for the last 6 years. Our family is devastated and heartbroken at the loss of our only daughter. It is unfathomable to me that my 16-year-old was legally capable of giving consent to her teacher, who was 49 years old at the time, and her father and I having no legal recourse against him. Mr. Perez knew the laws when Kristen was 16, and when she turned 18, he had her sever all ties with her family and friends. We were unable to break that bond and separate them, and because of that, we have lost our daughter. We cannot continue to allow individuals whom we trust with our children and that are in a position of authority to engage in sexual relations with them and then give them the legal right to use that consent as defense. We pray each day for Kristen's safe return home and that she will come to the realization that she is in fact a victim. Please do not continue to give these predators the tool to allow this to continue. I ask that you support the Senate Bill 868 and 869 so that other young people are not victims of predators who are in a position of power over our youth. Thank you for listening.
Thank you for hearing me. My name is Brenda Demers, and I'm running to ask you to vote in favor of Bills H. 1374, H. 1348, Senate 868, and 869. I'm advocating in favor of these bills as I would like to see the age of consent raised to 19 in both criminal and civil matters. My name is Brenda Demers, and I'm J.C. Demers' mother. In August 2013, we moved to Florida. 2 weeks after being there, we received a phone call from the principal at our daughter's high school in Massachusetts. He informed us that a teacher at Blackstone Valley High School in Massachusetts had a sexual relationship with our daughter, and she was only 16. I sank to the floor crying and in disbelief. Mr. Maddie was our daughter's special education teacher, and he used his position to influence a 16-year-old girl into having sex with him. This certainly is an age that is extremely impressionable. These acts he carried out are serious, thoughtful, and deliberate, not only as a person, but even worse, from the position of a more prominent role as a teacher. While our daughter needed extra help and struggled in school, she looked towards her teachers and aides for guidance, help, and encouragement. She entrusted that they were directing, steering, and assisting her in the best way she needed. We as parents also believe this to be true. While the rest of her teachers did just that, Mr. Maddie took complete advantage of this situation, used his orientation to manipulate her when he saw a child fight to just maintain and keep up with her peers. His position was to aid in her improvement, and he greatly let her down in so many ways. She is left in a worse position now than she ever was, just needing extra help in school. These circumstances have in no way been for the better for our daughter. In actuality, Mr. Maddie preyed on his student. Mr. Maddie took a video and vile photographs with his own hands of himself and our daughter having sex. He sent these over the internet. He coached her how to lie and evade us as parents. He deceitfully had her meet him out of state so he wouldn't be recognized. Using his age difference and knowledge, he influenced her. He brought her to his family home and introduced her to his parents as a 21-year-old girlfriend. Almost as if he had no conscience, he sent JC letters and cards telling her he couldn't wait to be with her and that she was worth the risk. Admitting he knew this was wrong, it didn't seem to bother him, he continued. Mr. Maddie has photos and a video somewhere of our daughter. We have no idea what he is doing with them or what he has done with them. We have no idea if he has even shared them. The sheer magnitude that he even took them is more alarming. These were his actions. He placed himself in this position and thought he could get away with it. People are most sorry when they get caught, not before or during. While JC is sentenced with a traumatic past and future, our family is sentenced to picking up the pieces, which will surely take years. Mr. Maddie should also have some sort of punishment, as he is a major factor in this train wreck. Please remember, as he said in his own words, that she was worth the risk. We are unaware if Mr. Maddie is capable of stopping this unethical behavior and aren't even positive if our daughter was the only one that he did this to. As he may say he would never do this again, there were reports and issues that he had trouble with a girls' soccer team at Northbridge High School before my daughter, proving that we all know very well when caught you will say anything to save yourself. In conclusion, we moved back to Massachusetts early 2015. It took our daughter 5 months to move back home with us. She was out of the house before that and wouldn't speak with us. She feels ashamed of what has happened, thinks people look down on her, and frankly is just having a hard time getting past this chaos. She has been admitted into the hospital for a week with this being the main issue for her severe depression. She is on medication, seeking counseling, and we are all very much a torn apart family. Mr. Maddie needs help, but his actions should be viewed as much more. He is a threat to young girls everywhere. More and more teachers are taking advantage of their positions, and there needs to be an end. This bill will send a clear message that this is no longer tolerated, and the welfare of our children is important. Pedophiles come in all forms, trench coats, online, predatory, even teachers. They aren't going to stop themselves. They need serious deterrence. These bills are a fairly merciful and forgiving sentence when the victims and their families will always live with the activity and fate that these adults have created. Raising the age of consent would protect students and children from harm that can easily be avoided and should never have happened in the first place. As a teacher, he certainly should have known better than to put himself in that position. These teachers have a job, and if they aren't willing to do what is suitable and in the best interest of their students, there needs to be consequences. Thank you very much. Can I just give these to you?
Chairman Fernandez has made the point to me that it may make most sense as we tell these stories not to refer to either the perpetrators or the victims by name, since they're not really present to defend themselves in any way. Not suggesting they deserve any defense, but just out of fairness, let's tell stories without naming names.
Thank you, Chairman Brownsberger, Chairman Fernandez, and members of the committee. My name is Jennifer Falcone, and I'm a lifelong resident of Massachusetts. I have come here today as a parent, as an advocate, and as a survivor of educator sexual abuse to voice my support for Senate Bills 868 and 869. When I was 11 years old and a new sixth grader at a public junior high school in this state, I became the target of an administrator at the school. What started out as compliments and extra attention turned quickly into molestation, rape, and then trafficking, all within the walls of the school building. My primary abuser used his position of authority at the school to pull me out of classes, to abuse me himself, and to bring me to other men waiting in an empty office in the school building. Some of these other men were also school district employees. He emotionally, physically, and sexually abused me into compliance. Meanwhile, the culture of the school supported this man in his abuse. A few staff members acted concerned for me but were easily appeased by my statements that everything was fine. Others noticed but looked away. Some didn't even look twice when my primary abuser came to pull me out of class. In fact, I was absent from physical education so often that I was shocked every time my report card showed an A in that class. I was completely trapped in the worst of nightmares at a public school, a place that was supposed to protect me. Until my children grew to be school-aged, I rested comfortably in the fantasy that schools were safer places now. However, I now know that this is not the case. Not only does our state not require sexual abuse prevention training for school staff members, but also there are no laws preventing educators from enticing and manipulating students that are of the age of consent. Children that are not considered old enough to vote, smoke, or drink alcohol are somehow supposed to protect themselves from adult sexual predators. All around, our state laws are fundamentally failing to protect kids at school. Sadly, children that are most vulnerable because of abuse or neglect at home are the ones that will be targeted by many sexual abusers. Senate Bills 868 and 869 are steps to create safer school environments for kids. Sexual abuse and sexual enticement by educators have no place in our schools. We need to send a strong message to all sexual predators that schools will not be a place to target vulnerable kids, no matter the age of the child. No child should have to endure what I did, and parents should know that schools are doing everything possible to protect their children from sexual abuse. Our children depend on us to protect them. Thank you for the opportunity to testify before you.
Thank you for coming forward with that. Attorney Russo.
Thank you, Senator Brownsberger, Representative Fernandez, members of the committee. My name is Carmen Durso. I'm here to speak on behalf of 6 bills that are on this subject. House, Senate 868, 869, House 1347, 1348, House 3787 and 3788. And if I might have your indulgence, I'd like to address another bill after that briefly, which is related, Senate 1374. The first 6 bills consist of 2 groups, 3 bills that deal with criminal penalties and 3 bills which would establish civil action whenever an employee or contractor with a public or private school or with certain specified state agencies which provide services to vulnerable children engage in sexual activity with a person under one set of bills under the age of 19, under a second set of bills under the age of 18. There's that difference between some of the bills here. I've heard what you heard in these stories, and of course I hear these kinds of things all the time from people that I represent. What I get the opportunity to hear sometimes is the specifics by which a perpetrator will wait until a child is over the age of 14 before he will touch a child sexually, because the indecent assault and battery statute relates to children under 14 and has a longer statute of limitations, and then that they will wait until someone is over 16 before they will engage in the other kinds of activities which we classify as rape because of the consent age of 16. What we see in here are people who are very skilled at manipulating children, as you heard, getting them to believe that they're going to have a life together. There was one teacher in a private school who told 2 boys, both 14 years old, that each of them at different times when they were attending the school, that she was going to leave her husband and her children, and the 2 of them were going to spend the rest of their life together. As one of the 14-year-old boys, as one of the adults, now adult boys, said to me, I was 14, I had no idea what that meant. All I knew is that I was overwhelmed by the feelings that this woman gave. When this woman was found out, the people in that school sent her emails saying, not what a terrible thing that you were sexually abusing 2 14-year-old boys, but rather, you're a good person, you'll get through this, we understand this is a hard time for you. People in education don't understand that they have a crisis on their hands, and that we are starting to see numbers of people who are sexually abusing children in education that are starting to rival what we used to see in clergy abuse. There's a report by Cheryl Shakeshaft in 2004 which indicated some of the numbers of people that we're seeing. But all the reports make clear we're seeing very small numbers because of the reluctance and the inability of the people who are abused to do anything about it until they get to an age when they're mature enough to understand that they've been used by these teachers for their own pleasure. The other bill I want to call to your attention is Senate 1374, and that's an act to stop educator abuse, misconduct, and exploitation, the Sesame Bill. This is a bill which would set up a series of standards and make it clear what kind of investigation would have to be done before you hire a teacher to make sure that when a teacher has been involved in these kinds of activities, they can't easily move on to another school. And we see this. We see this a lot, particularly in the private schools. But we also see that in the public schools, that teachers who are accused of misconduct are strongly defended by their unions. And I've talked to administrators in schools, and they are actually in fear of accusing a teacher of something like this because they know what they're going to have to go through, both administratively and legally, if they accuse somebody. It's only if the legislature adopts strict standards like this, both in terms of the age of consent and in terms of the kinds of things which institutions must do, public and private, in order to deal with the people, the small number of people in education who would take advantage of children. Only then will we start to see that we can cut down on the numbers of children who are being abused in these situations. Thank you.
Thank you, Attorney Joseph. Thank you so much. Questions for any member of the panel, from members of the panel, of our committee? Representative Dunn.
Thank you, Mr. Chairman. Attorney Dorsey, I'd be interested in your opinion on two matters. One is 868 and 869 both contemplate sexual abuse. I wonder if the appropriate term would have been sexual contact rather than abuse. I'm just concerned that people may